Interchange, weekly conversations with Stanford scholars working on the frontiers of knowledge. Host of Interchange is Jim Bettinger, Deputy Director of the Knight Professional Journalism Fellowships at Stanford.
Welcome to Interchange. Our guest today is Margaret Jane Radin, Stanford Law Professor and co-director of the Stanford Cyberspace Law Institute. She's an acclaimed theorist on the concept of property and an authority on the world of information technology, that sprawling phenomenon we call the Internet. Thank you for joining us, Professor Radin. Let's start with a basic. What is cyberspace and why do we need special new legal concepts to deal with it?
Thanks for inviting me. There's no one canonical definition of cyberspace, but here's how I think of it. I think of it as a realm of interaction where human beings communicate with each other through networked computers. It's also called the online environment.
Mm-hmm.
Networked computers is what's essential. It's only metaphorically a space or a place,
mm-hmm.
but it's hard to avoid the metaphor because when people do start communicating that way, a feeling arises that they are in a space. So that's why it's called cyberspace. Actually, the term was coined in a novel called The Neuromancer, you may know.
And
why is it?
Why do we need special new legal
yeah.
concepts to deal with this quasi-space?
Right. Well, that's a very interesting question because some people think that we don't.
Mm-hmm.
I could start with why we might need special legal concepts
Please.
For the new space. One is the new space is global. It's not territorial,
mm-hmm.
but government law is territorial, so that if it became pervasive that we communicated in a global way. I mean, not just talking to each other personally through email or in chat groups, but if we did all our business that way, if we did our banking
mm-hmm.
that way, if the borderlines broke down, then it would be hard to understand what jurisdiction might mean. It would be hard to understand
mm-hmm.
what territorial law might mean. So one school of thought says because it's going to be very hard to understand what territorial law could possibly mean, the bits go anywhere and they
right.
don't care.
Right.
We won't be able to use the law as we find it. But there is another school of thought, really, that says, well, you know, they said that about radio and the telegraph, and this is a new medium of communication, and we will have to adapt, but
mm-hmm.
we can adapt and we can use the legal concepts that we have. It's not necessary. We can have evolution and not a revolution.
There's also an argument, I think there's an argument that we shouldn't try and regulate the Internet at all,
yeah.
that it should just be the way it's sort of grown up, free form, somewhat anarchic.
Right.
Why couldn't we just let the Internet run wild, as it were?
Well, that's a very interesting question, too. The Internet is self-organizing, famously so. The way the messages get around is by rooting themselves in the way with the least interference. And it's a powerful metaphor to think that human affairs could do that, too. There's a really kind of traditional school of political thought that all of human affairs would be best ordered by voluntary contracts between individuals, somewhat anarchic.
Mm-hmm.
And that's kind of a marginalized political thought as far as real space goes, but on the Internet it's not marginalized at all, and there's been a great resurgence of, for example, thinking about the Austrian economist, thinking about Friedrich Hayek, who mm-hmm. said spontaneous ordering is good and planned ordering is bad,
mm-hmm.
and so this kind of ideal or ideology, if you will, is having a great resurgence in cyberspace, and you know, people who say market solutions are best no matter what translate themselves to people who say spontaneous emergent solutions, evolutionary solutions
mm-hmm.
are best no matter what. I think the picture is more complicated than that. There are some things which don't emerge too well just through spontaneous interactions between individuals. And
such as, in terms of your internet,
yeah.
what would you fear would not emerge?
Well, as a general matter, overarching human rights don't emerge too
mm-hmm.
well that way. They have to be kind of nailed down by agreement from the top, I think, most
mm-hmm.
of the time. And so while we can have customs about how we can make contracts and exchange goods, although even those have to be standardized to some extent, so we'll know what would be duress. That may be different in one country than
mm-hmm.
in another. So we'll know what would be unconscionability and overreaching against people. But I think the realm that really isn't going to do too well with emergent ordering is personal privacy. And one of them, at least.
Yeah. In what way? Well, I mean, it would seem in some sense that the internet was the most private. You can be almost
Right.
anonymous on the internet.
That's right, you can.
But so what's at stake for privacy rights?
What's at stake for privacy rights, I think, is that marketing cuts the other way. Once it becomes a really global, important commercial way of reaching people and trying to sell them things, which it's rapidly in the process of becoming, the ways of selling people things are becoming more and more efficient. It used to be that certain marketing organizations could get data on me, but they couldn't share it with each other, and they in turn didn't know what my bank had or what the DMV had or what all these other organizations had. But as these all become just collections of bits which are in big databases, they can be amalgamated, and then there are technological things. There's a thing called data mining where you can try and find out that demographic bit that you most want to market to. And I think many people don't know that the browsers that we use have a thing called a cookie. Do you know what a cookie is?
Well, I know a little bit what a cookie is, but
Right.
I'm sort of just recently become
Yeah.
aware of it. Talk about cookies and how they might be a threat to personal privacy.
Well, the non-technological definition, which is the only one I can give you, is that a cookie is a piece of software that is built into the browsers, Netscape and Microsoft
Right. Explorer
and whatever one you might want to use, which when you access a website, it communicates with the browser, with the central station, and tells where you've been. So it's really like in real space, you know, when people want to do something secret, they can't use credit cards because the credit card receipts will show where
Right.
you've been. Well,
Right.
the cookie communicates back through the internet to this central place and can tell where you've been. So if, for example, you visit a lot of sites that sell wine and cigars, you're probably going to get a lot of email which tries to sell you those things. And it could be more insidious. You could visit a lot of sites which might be illegal in this country. There are gambling sites, there are sites that are pornographic, but they might come out of Denmark or Finland where they wouldn't be regulated. And it could be, it's not very private. People could have the goods on you without your knowing it in a certain sense.
What level of sort of technological expertise does it take to make use of cookies? I mean, so let's say I click on a gambling site. I mean, how savvy does somebody have to be to figure out I've clicked there? How does that, I mean, I'm not really clear how that works.
Yeah, I'm not sure I am either. I think there's two different things at issue here. One is whether the organizations that have access to the files of the browser, then the browser can license them for that. In other words,
Gotcha.
Netscape can make its money through selling these things, or the bank can make its money through selling its files, and there are data organizations that gather up the data from all kinds of organizations and amalgamate them together and then sell them to people who want to market. So that's the marketing business as it's happening. So that's not hard to do at all, but it's a little bit harder for someone who just happens to want to eavesdrop to see what's going on in your messages. But unless they're encrypted, they can do that. There are techniques whereby someone can set up a server and they can attach. Some of these things have picturesque names. They can attach something called a sniffer.
A sniffer?
Yes, and it will. It sniffs out certain kinds of messages.
Really?
For
Okay.
example, it is said that someone could, without too much technological expertise, set up something that could sniff credit card numbers or the pins associated with them, which is why they're developing encryption standards to try to make that much harder. But you know, one of the things that's also to be said about this is that the forces of trying to defeat these things also proceed apace. You know, so there are cookie kill files now, and you can go to certain places that have shareware, even which you can get for free, and you can take a piece of software which you can put into your hard drive, and you can hit a button and it'll kill the cookie. I have a cookie
You
kill
have one.
file.
You have a
Yes,
cookie
I do.
killer. Yeah. So it's
I do. Cookie killer is called. Yes.
Yeah, that's and that's a way then of masking your where you've been. Oh, yeah. Okay.
Right. Right.
You mentioned sites, you know, that might have illegal activities,
Yeah.
pornography, gambling, which are I would guess probably in this country the pornography is the sort of the bugaboo that's held up the most.
Right.
Is here's why we need to restrict access. How are governments going to deal with these shifting definitions of what's legal in one country and the access? I mean, you mentioned that the internet sort of obliterates geographical distinctions.
Yeah, before I respond to that, I'll say that it's not just pornography. It's fraudulent Ponzi schemes and unregistered securities and gambling. It's a great many things. I mean, and some of the crypto anarchists, as they call themselves, even think that it could develop into full-fledged murder for hire. There'd be a way of marketing your services as a hit person and having no one know where you were or who you were. So there is a thought that there are some risky activities, not just ones that represent cultural differences like pornography. I mean, I'm fond of saying that in this country we think pornography is bad, but in certain parts of the world they think blasphemy is bad. And if we could censor everything for the lowest common denominator, there wouldn't be too much internet left. The alternatives are, I mean, many people think there are some promising technological solutions which will do the censorship for you. There's a thing called the PICS standard, P-I-C-S.
What does that stand for?
I don't know.
Platform something.
Yes,
all right. PICS, P-I-C-S. All right.
P-I-C-S. It's being developed by an industry consortium, and people will be able to register with that what kinds of things their sites contain, and then if at any level, either at the individual level or at the organizational level, or even at the country level, for example, if you're Singapore, you might be able to say, okay, into Singapore, I'm not allowing anything to come in that has a certain kind of PICS rating. So there's a way that the technology can be used for even stricter censorship than we've been able to do with the law, because after all, in the technological sense, it just can't come in at all if it has a certain label on it. Implemented technologically, whereas with the law, you have to run after people and try to catch them, and oftentimes you can't. So many people are saying now that what's going to happen with the technological restraints is a kind of zoning. It's not going to be this gigantic free space at all, but rather a space that's rather highly zoned, analogous to what they call the erogenous zones in legal doctrine. Have you heard about that?
Tell me that.
Well. The Supreme Court has upheld the idea that you can zone your city in such a way as to make the erotic, the Pussycat Theater and the erotic bookstores be in only one zone, and that's not unconstitutional, doesn't violate free speech, doesn't violate their property rights, and so on, even though it does give some disadvantage to people who want to go there because they have to travel to the erogenous zone if they want to view the material. And so by analogy, it's thought that that technological fixes could be invented which would make it harder to get the stuff, but it would still be possible. So it is thought that the Communications Decency Act could perhaps be amended to go at it that way. Most of my academic colleagues and I think it will be declared unconstitutional the way it is now, because the compelling state interest that it's supposed to make it constitutional is keeping the bad material, the indecent but not pornographic, obscene material out of the hands of children. And I should say that you can't keep it out of the hands of the adults because it's not obscene, therefore inside the scope of the First Amendment. So you have to find some way to just keep it out of the hands of children. And right now the Communications Decency Act is way too broad to do that.
Is there anything salvageable in the Communications Decency Act, or should Congress start over, or should Congress not try and do anything along these lines?
Well, I don't know what Congress should do. I think that many people are severely disturbed about children obtaining this stuff. I have children, but I think many people do think that parents could somehow, if technological blocking software or if rating systems are made widely available, that parents could deal with it themselves. And in that sense, there is some strong idea that maybe we should let parents try to deal with it before we decide that there's this terrible thing that needs fixing, especially since it's very hard to think that the Communications Decency Act will be efficacious, because whenever your site is labeled as something that should be blocked, you can change the name of it and move it to a software somewhere else, and it's going to be kind of the chasing its tail. So,
something you mentioned earlier raised another question. You talked about the technological solutions. Isn't there, it seems to me there's a fair school of thought that says that technological solutions will regulate the internet far more than any sort of imposed laws will. Do you think that's accurate, and is that a good thing?
That's an interesting question. It's accurate now, I think. In other words, the internet came about because groups of engineers who got together informally decided that certain things worked. The motto is rough consensus on running code. So they got a consensus that TCP/IP, which is the internet protocol, IP stands for Internet Protocol. All the computers that are networked on the internet have to run that code and no other. And if you run something else, you can have a computer, but it won't be online. And so that, in a sense, is kind of an iron law of being on the internet, unless someone tries to connect another internet. So it could be argued that certain standards like that are running the internet. But at the same time, I mean, the issue in real space too, the issue of what sorts of standardized things develop through evolution and individual action in markets should be left to stand because they're efficient and good for everybody, and what should be regulated to some extent. That's a very difficult question. I mean, it could turn out that everybody will standardize on the software that Microsoft has because there's a tipping point and we're long past it. And so if that happens, it could turn out that that's monopolistic and bad for other people who might invent better things. And that's why we have antitrust laws. It could turn out that all of the websites will find a contract which will, the click wrap license, they call it, sort of analogous to the shrink wrap license. Maybe I should explain. When you buy software, it's wrapped up in plastic wrap, and it'll say, by breaking open this package, you've agreed not to copy this, you've agreed not to re-engineer it, you've agreed to give us your life, and you break open the package. You'll be shot. And that's called a shrink wrap license. And the legal validity of that is pretty much in doubt because you didn't really have much of a chance to agree to it. But one could argue on one side that if there's lots of different ones in the marketplace, you could pick it up in the store, and if you don't like it, you could put it down and get another one. But it's another thing if it becomes standardized. So, for example, if it becomes standardized that your website, all websites have something which they call a contract, which says by accessing this, you have agreed that all of the data that we get on you can be sold to marketers, and you have agreed that you won't post anything which we consider defamatory, even though you think it's protected by the First Amendment privilege and so on. If that became the standard, then it would arguably be something which the law should interfere with and say, well, I don't like that standard. There is such a thing as the First Amendment still.
That makes sense.
So it's a complicated issue in real space, and I think it'll be a complicated issue in cyberspace as well. Some of them should evolve, and some of them should be handed down, I think.
And we're still trying. I guess we're still trying to figure out who should decide.
We are.
When the tipping point for these points.
Yeah, we are.
Let me ask you about something a little different. You said that the internet is moving from a non-commodified system to a commodified system. What do you mean by that, and what are the implications of that?
Commodified. By the word commodified, that's kind of a jargon word, sorry, for treating everything as if it were a market or should be thought of in market value. And the internet is a really interesting case study of moving from a non-market way of thought to a market way of thought. When the internet originated, as most everybody knows, I mean, it started out as a defense initiative so that messages could be gotten through if part of the system was down, but it began to be used by academics and scientists, primarily engineers and scientists, to communicate their research and communicate with each other. And information was freely shared. There wasn't a question of selling. There wasn't a question of marketing. It was what I would think of as a non-commodified space. Property rights were not thought about. People forwarded on their email without thinking that, well, I'm the writer, I own a copyright in the email, but in fact you do. As the writer, the copyright is with you. People didn't think, when someone sent them something, they sent it on to friends. They didn't think, well, there's property ownership in this. But what's happening now is it began to be recognized over the past 5 years.
5
maybe.
years.
5 years maybe, that there's vast commercial potential. But in order to realize it, the things of the marketplace, the values of the marketplace, in particular property rights and contractual ordering, have to replace this kind of communitarian sharing that the old internet had. So that's what I mean in changing from a non-commodified to a commodified space. The meaning of that is still unfolding. Many people thought, from the point of view of political theory, from the point of view of democracy, and from the point of view of the role of communication and information in democracy, that the old internet, if it could become bigger and broader, would be a wonderful thing for popular government and the information of the populace, undominated dialogue, as they say in political theory circles. And what I wonder is whether any of that will be left after the commercial transformation. I mean, I think there's hope that some of it will be left, but I think it's in doubt. It could be that we'll end up with a completely commercial network whose structure will be in fact dominated by the commercial players and what they need for trade to take place, and therefore it could be that the political ideal of becoming better informed and having more public debate will go by the boards, but I'm not sure yet. Yeah.
Can I assume that you would think that some authority ought to either be imposed, or some authority ought to take the responsibility for preserving some this non-market part of the internet, some things that are just pure communication, pure creativity, whatever that might be?
Yeah, I'm not sure that I think some authority should take charge right now, but I definitely think that everybody who's thinking about the future of the internet should think how it's going to serve humankind, and not just in humankind's need to exchange through markets, but in humankind's need to exchange feelings and thoughts and learning and information and the things that we need to be a democratic environment. And one of the things that's very touching is because of the encryption program, Pretty Good Privacy, which somehow got exported even though it wasn't supposed to be, because our government classifies those things, strong encryption programs, as munitions under the...
As munitions?
It's munitions, so that therefore you're not supposed to... But it got exported and no one knows who did it. And the people in more oppressed parts of the world that have this program, they're actually out in the hills fleeing oppression, but they're communicating with computers using the encryption, and they're sending messages back to Phil Zimmerman, who invented the program, saying, "Thank you very much, I'm still alive because of you." So it's not just in this country that we hope for more democratic openings. We can hope that the rest of the world can find out what the more democratic parts of the world are like, and have some hope. So I would think that we should all think about that. And while I don't know whether any one authority should take charge of it, or whether there should be a kind of grand internet democratic sovereignty treaty at some point, I do think we should think carefully about that. We should think about what freedom of speech means in the online environment. And for example, we should take care that property rights don't engulf it. I mean, because people are trying to learn how to implement copyright and other property rights in the online environment, we are kind of in danger of forgetting about free speech. Because if we implement machines that can enforce what people think is their copyright without any chance to even argue about it for the people who may need the information for free speech activities, I think it does really encroach on what we thought free speech was. So I think we should keep thinking about those things.
Well, the export of the Pretty Good Privacy raises something else. Is that with the internet, it seems almost impossible to control the flow of information. Right. That's one of the great things about it. Yeah. And so you might, even though the government classifies this as munitions, bang, it's gone. And Esther Dyson of the Electronic Frontier Foundation has said that basically copyright law as we know it is gone, that there'll be, that all of this content will be free, and then what will be enforced is some ability to sell follow-up services, such as, the software is free but the support costs you. Do you think she's right on this, that copyright as we know it is gone, or not?
Well, no, I think she's wrong, although partially right, perhaps. Property rights change around a lot. Property is an evolutionary concept. They used to think in legal history that it was metaphysical, and but by now we don't think that anymore. We think that property evolves according to what people need to use it for, and in particular, it evolves depending on how much it costs to protect things under a property regime versus letting people grab them and how much that costs.
Right.
And so she may be right that certain things are going to be much cheaper to distribute and much cheaper to produce, and therefore it would be expensive to try to protect them. And she's also right that it would be expensive to try to protect them just by traditional law, where you try to catch people who copied it and then go out and seize their machines and take them into court and get an injunction. However, after she wrote this, I think, to be fair to her, the development of trusted systems really speeded up, or the development of copy protection, and they're in the process of writing codes, writing machine languages that can really protect your copyright much more in an ironclad way than the law could have. So even if something becomes pretty cheap, and it may be even cheaper to sew it all up with a software that won't allow you to download it, for example, or will only allow you to have it for one day to read it, and then it will self-destruct. And will send some alarms back to where it came from if you try to share it with a friend. So if that's what comes about, that particular regime, then I think she really is completely wrong, and not just partially wrong. But that regime may not come about. I mean, I know that many commercial interests would like it to come about, but consumers may hate it. They may not want to purchase it, or they may be very angry and protest, and they may, the hacker culture may say, this really challenges me, I don't want this. So I think it's too soon to say. But she surely was right that we were going to have to kind of rearrange how we thought about intellectual property, and that's still true. But unclear how we're going to do it. I don't think copyright is dead by any means. I mean, the United States has some initiatives to make copyright much stronger, in fact, to make it a crime to tamper with copy protection systems, or to make anything that could be used to tamper with it, even if you don't intend that it do so. And not only is that initiative pending from this administration, we are making a good effort to sell it worldwide, and have a treaty that will do that too. So.
Well, I feel like we've really just sort of scratched the surface here, but we're running out of time. I want to thank you very much for joining us today.
Thank you so much. It's been a pleasure.
Well, good. We've been talking with Professor Margaret Radin, Stanford Law School. For Interchange, I'm Jim Bettinger.